Shobhoshaji Chatterjee, Sir, Advocate at High Court, Calcutta, respected faculty members and the students to the inaugural session of Lex Conclave 2026, a prestigious academic initiative organized by Sureshwar Datta Law College.
Sureshwar Datta Law College, established in 2014 in Howrah, West Bengal, is a remarkable institution dedicated to excellence in legal education. Founded in memory of late Sureshwar Datta, a renowned philanthropist, educationist, and social reformer, the college is affiliated to the University of Calcutta and Bar Council of India. The college offers ethical and socially responsible legal professionals. Under the leadership of our Honorable Chairman Sri Amitabh Datta Sir, the institution provides a supportive academic environment complemented by facilities such as a library, moot court, and a computer lab, making it a respected destination for legal studies in West Bengal.
Lex Conclave 2026 is envisioned as a dynamic platform for intellectual discourse, legal awareness, and meaningful engagement with the contemporary issues that shape our society and legal system. Through this series, we aim to bring together eminent speakers, legal luminaries, academicians, professionals, and experts from diverse fields to share their insight and experience on subjects of current relevance. In an era where law continuously evolves to meet the changing needs of society, it becomes essential for legal professionals to enhance discussion that go beyond textbooks and as well as classrooms. Lex Conclave seeks to bridge this gap between critical thinking, informed debate, and practical understanding by pressing legal and social concerns.
Today marks the beginning of this exciting journey. The first session of Lex Conclave 2026, being held on 23rd of June, is dedicated to one of the most fundamental and significant branches of law, constitutional law. As the Constitution serves as the supreme law of land and the cornerstone of our democratic framework, understanding its principles, contemporary challenges, and evolving interpretations remain crucial for every student of law. This conclave is not merely a lecture series. It is a step towards creating a culture of continuous learning, academic excellence, and legal consciousness. We hope that each session will bring meaningful conversations, broaden perspectives, and encourage participants to critically engage with legal issues of our time. As a student of Sureshwar Datta Law College, I extend a warm welcome to everyone present here to be a part of this significant journey.
It is my distinct privilege to introduce our esteemed speaker for the first series of Lex Conclave 2026, Sri Shobhoshaji Chatterjee Sir. Advocate Shobhoshaji Chatterjee Sir is a distinguished advocate practicing before the High Court at Calcutta, known for his dedication to the legal profession and his commitment to justice. He began his legal career at the Howrah District Court and since built a diverse practice encompassing constitutional, electoral, and criminal law. He has completed his graduation from M.S. Ramaiah College of Law and completed his schooling from Howrah Zira School. Apart from his legal practice, Sri Shobhoshaji Chatterjee Sir serves as an assistant director of the Indian Law Journal and is an active social activist. He has also participated in several national moot courts as well as international moot courts. He has handled writ petitions, political defense cases, and matter relating to Special Intensive Revision (SIR) of electoral law. Advocate Shobhoshaji Chatterjee Sir gained prominence for his role in the landmark 2020 Calcutta High Court PIL on COVID-19 safety during Durga Puja. This historic verdict imposed strict crowd restrictions at Pandal, reflecting his strong commitment to public health, rule of law, and constitutional responsibility. He also acted as a defense counsel in the notable murder case in Mushida.
Recently, he brought before the Calcutta High Court an important public interest matter concerning the dignity and rights of accused persons, reflecting his steadfast commitment to the rule of law and protection of fundamental rights. He was also a candidate in 2024 Lok Sabha elections from Howrah parliamentary constituency, giving him valuable insights into democracy, governance, and public policy. Today, he'll be sharing his valuable knowledge with us on constitutional law and its emerging issues, a topic of immense significance in our rapidly evolving legal and socio-political landscape. Please join me in extending a warm and heartfelt welcome to Advocate Shobbashati Chatterjee sir to our own Shureshwar Datta Law College with a huge round of applause. I request the felicitation team to be prepared.
I request our honorable guest, Shri Shobbashati Chatterjee sir, to please come up on the dais and join us for the felicitation ceremony. I request the audience to please give a big round of applause as he comes to the dais. May I now request Srijita Das from second semester to felicitate our honorable guest, Shri Shobbashati Chatterjee sir, Advocate at High Court, Calcutta, by presenting the Victoria.
The Uttara is a symbol of respect, honor, and gratitude from us.
A huge round of applause for our honorable guest.
Thank you. I call upon our student Sneha Das from second semester to present this memento to our honorable guest.
This teaching is a reflection of our heartfelt gratitude and the honor we feel in recognizing you. Thank you so much, sir, for your presence at the Lex Conclave 2026. I request Rishika Singh from second semester to present our honorable guest with a sapling. This represents our admiration and gratitude and the growth in this legal journey.
Thank you, Sanjana Dev from second semester for assisting us. And thank you, felicitation team. Thank you, sir, for sparing your valuable time with us.
Now, sir, with your permission. Thank you so much.
Now, first of all, I say sorry to all of you for my late coming. I'm already late by 2 hours. I think you are scheduled to be held at 2. Now we are at 4. Something should not be followed. This is one of those bad qualities. But when you go to the court, when you are in dispensation of justice generally, you become a court officer of the court, and you are bound to do those works, and then you have to categorize your work, you have to prioritize something. So today I had such a work which I could not avoid. So I had to seek a permission from our respected teacher of this college that I am coming and be a little bit late. But when I came out from the court, and then the thunderstorm came. And you know what happened? We were late by 2 hours. But I will try to devote my time to give you some of the impression about the constitutional law, and as the topic has been fixed by your teachers, contemporary issues, emerging perspectives. So it's going to be a general discussion, but this discussion will be based on the standard of the students who are here. I just want to know that how many of you have already done constitutional law in your syllabus. Please raise your hands. The rest of you have not. Right? However, all of us, we must have some of the idea about the constitution, and those who have not read constitutional law yet, I would insist them to read it, at least read this document. This is very important. The most fundamental thing about the constitutional law is to reading the constitution again and again. because this document has a tremendous history of devotion, dedication, research, perfection and vision of the father of our constitution. I would like to say that forefathers of the constitution. It's not the father of the constitution as we know. Dr. Ambedkar was the chairman of the drafting committee of the constitution. Right? In brief, that how to read this. This is the most important thing. In our practice life also we have seen, those who are in academics also they have seen, that we need to know the subject first. Then we need to apply it. All of us. You may be in research, you may be in academics, you may go for any corporate office to do your job. You may work in any of the court, but what you are required to know is the subject from your code. Law is a practical oriented subject and problem oriented subject. There are problems which comes to us, to the lawyers, to the teachers also, to the lawmakers also, to the executives also. So all we require to solve the problems and solve the problems in accordance with law. And when we say that, we say about the law as it is in the book. So I will be telling you, it's my understanding, there cannot be any better way of learning rather reading the textbooks of law, bare acts of the law. So you have to first read this. If you ask me that what do we learn in 5 years of our law studies? What? Do you really learn law? Can anybody tell? What do you learn in 5 years of your study? How many of you can say that I know the law in 5 years? I've learned the law. I think nobody can say, because even the most prominent lawyer of the India will not say that I know the law. What you learn actually is how to read the law. How to read the law. That is the endeavor and that is the hard work. Our teachers, they try to inculcate within us in 5 years how to read it and how to find out the law. And when we go to the court, we find out the way how to apply the law. When we go to any other sphere, we also try to find out that how to apply the law in that particular context. Now, constitutional law, as someone was telling, that it's the, what is that? Grand norm, right? The mother of all law. Let's not stick to that very age-old concept of jurisprudence, that grand norm and all. Let's come to 1950. Let's have a new beginning, as India had its new beginning in 1950. And that is the India. That is the India. When we say about India, today's India, it is 1950 Constitution defined India, nothing else. We cannot say that. That's why Constitution is like the deed of your house. It's the deed of our country. I mean to say, how many of you have heard about deeds, document, covenants? It's the country. Suppose a house has a deed, you have purchased a house, you own a house. So that's the document. Constitution is the document of the nation. And you may like, you may not like, it's the political document of the nation. It's a hardcore political document of the nation, and this is what the forefathers wanted to create. The Constitution has shown that. I would be telling you few situations and then you will come to these contemporary issues. You will find, today I am not going to give you any issue, you are going to fix the issue. I will only tell you the law. You will try to find out the similarity with our contemporary situations. So I request you, all of you have the phone, mobile phone. Please open the Google and open the their constitution. All of you. Because that's the first technique we need to learn. Hello. So all of you please open that and let's come to the preamble. We learn how to read it. As we learn how to read the law in the college, because no law college, law schools of the world can teach you the law, because it cannot be taught in 5 years, 2 years, 3 years, even 10 years. You may require 60 years also to learn some of the law. Then also you can say that I am just picking up the pebbles from the seashore, right? And these are not my words. You might have heard about another very renowned lawyer of our state, former Advocate General of the state, Mr. Kishore Babu. Once he told me that, look, you the young people are doing it now, and I was once a young lawyer. Then I met Mr. Ashok Sen. How many of you have heard about Mr. Ashok Sen? Ashok Sen, he was the former Law Minister of India, and he was also considered to be the best lawyer at that point of the time. Mr. Ashok Sen, according to Harish Salve, that yes, I was a junior to Mr. Palkiwala, but according to me, the most brilliant lawyer of the country was Mr. Ashok Sen. He had been the Law Minister of the country, he had been the Solicitor General of India, every post. So he used to say that I am also a law student when he was like 70s. So let us be the student in the class. Let's learn how to read. I will take you to the preamble first and let us read it together. Can anyone read it for me? Anyone? I want a volunteer. Who want to volunteer? Come. Read it. Read it word by word.
Hello. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, ensuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution.
Now, I would like to ask you a few questions which would be within these four corners of this page. Tell me who have adopted the Constitution? Who? We the people. How do you know? How will you describe this we? You. Where were you? In 1950? Were you there? Were you born? Your ancestors. How did you get this? Your ancestors falls within we. Will you fall within the definition of we? How? You give your answer. It's not. I am not expecting any correct answer from the law. You give your answer from your concept. That's all. Why do you think that you are covered by the term?
In that time, our future generation are also falls under this definition.
Right? Any other answer? Anybody? This page has one word called P, and it has a reference to a time, 1949, 26 November. Right? Now, all of us None of us were born in 1949, 26 November. Are we covered within this week? That is my question. And if we are covered, if your answer is yes, then you have to give me reason. What could be the reason? She has given a reason. She has given a reason. She said, tell me again, that your ancestors.
Our ancestors and our future generations are also falls under the definition of we.
Why? Now, yeah, tell me.
Yes.
You wanted to say something?
They are the citizen of India.
You are?
They are the citizen of India.
Whether citizens are covered in this bill?
Yes.
Are you sure?
Yes.
Okay. Can you open Article 30? Just keep it for this time. Then Article 30. Article 30. Please open it and say Article 30. Okay. Well, now come. You will find your answer. You have said something, but you need a support from the book, right? We, the students of law, we believe in authority. Whatever we say, it should be backed by the authority. It should not be from our imagination only. That's the difference between a writer and a lawyer, or a judge, or a law student or law teacher. Let's see. All laws in force in the territory of India immediately before the commencement of the Constitution. What does it mean? All laws in force in the territory of India. প্রত্যেকে কিন্তু পড়ো বললে you will get the clarity. It is interesting. একদম সূক্ষ্ম জিনিস নয়. All laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provisions of this part means part 3 of the Constitution, shall to the extent of such inconsistency be void. The state shall not make any law which takes away or abridges the right conferred by this part, and any law made in contravention of these laws shall to the extent of the contravention be void. In this article, unless the context otherwise requires, law includes ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of law. And law in force means includes law passed or made by the legislature or other competent authority in the territory of India before the commencement of the Constitution and not previously repealed, may not be then the operation either at all in particular areas. Nothing in this article shall apply to any amendment to this Constitution made under Article 368. This is again. How many of you have understood this? Article 30, it talks about law. What is law? We have spoken about the preamble, and we were discussing about the word we. And my specific question was, how we who were not born as on date that is 26 November 1949, how will we be included within the definition of we? This specific question once it was asked to one of the American senator, and I read it from Mr. Nariman's book, and that book was where Mr. Nariman has stated that what is the answer of that American senator to this question, that whether this be covers us, whether is there any concept of constitutional inheritance
how have we inherited it? We have inherited it through this process of Article 13. Because Article 13 starts with all laws in force in territory of India immediately before the commencement of the Constitution. Stop here. So, immediately before the commencement of the Constitution, that means prior to passing of the Constitution on 26th of November 1949, there were the bundle of laws which were in operation in the country. Insofar as they are inconsistent with the provision of this part, then Constitution comes. Laws were there, Constitution came, it's like, purifier. It was like a purifier. Those laws which had passed the test of the Constitution then come. Insofar they are inconsistent with the provisions of this part shall, to the extent of such inconsistency, be void. So it purified that law. Those parts which were inconsistent with the Constitution on that day, those parts became void from that particular day. You got this point? So now these laws are started to travel. It's like a tunnel, how these laws have traveled into constitutional India. Constitution came. So these days very significant. You have to remember. We call it Republic Day. We don't know why do we observe Republic Day. There are reasons why do we observe Republic Day. It's the Constitution which on that day was adopted, it was enforced. And there, here you will find, come to this. The state shall not make any law. Now come to the future. From that day itself. This is for purification. And after purification, but the state shall not make any law which takes away, abridges the right conferred by this part, that is fundamental right. And any law made in contravention of this law shall, to the extent of the contravention, be void. So, from then onwards, after commencement of the Constitution, no law will be made by the state which are or which is inconsistent with the Part 3 of the Constitution of India. That is the fundamental rights. Understood? Now third, in this article, unless the context otherwise requires, law includes ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the course of law. Laws in force includes law passed or made by the legislature or other competent authority in the territory of India before the commencement of this Constitution and not previously repealed, notwithstanding that any such law or any part thereof may not then be operation either at all or in particular city. Clear? Now can anybody arrange the answer to the question whether you fall under this, whether I fall under this, whether the others? Can you just collaborate these two articles and preamble and Article 13? How have you inherited this Constitution? So this is the tunnel through which you have inherited. You can find, so there were a situation prior to the commencement of the Constitution, and the Constitution itself has prescribed the way which should be followed after the commencement of the Constitution. So it's an ongoing process. Law-making process is an ongoing process. And whatever our founding fathers have thought, that ideas have traveled in today, unless the Constitution is there. There may be a situation, there may be a deadlock situation for the Constitution. If you ask them how long this Constitution will survive, you can say that how long the people want the Constitution to survive. If the people want the Constitution to go, it will go. Because it has no magic in itself. Dr. Ambedkar said, even a bad Constitution may emerge as to be a very good Constitution. if it is handled by a number of good people. But even the good constitution may become the draconian constitution if it is given in the bad hands. So ultimately it depends on the bad hands and good hands. So we are clear about this. So how we have inherited this concept, whether we actually fall under this. People will say, this word was not there. I will not say anything. You will find out the similarity of the contemporary situations. I will not help you to find out any contemporary problems and controversy. I will give you the demonstrator situations, how constitution has dealt with it. You pick up the points and develop your argument. So now the question is, as it is, so it was there. Somebody will say, these words were not there in the original constitution. So how have it traveled? It traveled through the lawmaking process, law interpreting process. So today, one fine morning, someone will say that these were not there, so it is not there, so we will delete it. Constitution doesn't permit that. Whoever said it is that, they are anti-constitutionalists. I prefer to call them anti-constitutionalists. I have a right to say. Okay. So now, can you come to again preamble? Preamble. So you tell me when you are bored, you also let me know. So 4 or 5 problems I will create and I will try to solve you. I will try to give you the way out. Now I'll read it. The next, we the people of India having solemnly resolved to constitute India into a sovereign. What do you mean by sovereign? Sovereign means supreme. We have no external influence on us, right? That is the supremacy. Supremacy of the sovereign. When the supremacy can come, I will give you an example. Like a boy is playing on the street, doesn't have his parents, abandoned child. Now today, the CWC may pick him and keep him in the same custody. You know that under the law, that juvenile justice. And so a child who needs the care, they can be picked up. Now suddenly someone says that I am the parents and I want the custody of the child. Court may ask that you have to prove you are the parents, one. Number two, if you are parents, then whether you have the capacity to grow him up properly with all his requirements. Because ultimately he is a child of the sovereign. Sovereign has a duty to play to its subjects. So that's the sovereignty. The sovereign power is the supreme power. Our law will be made by our parliament without being influenced by any external force. That is the power. Our foreign policy should be decided by the sovereign. No external force can influence that. That's the sovereignty. Our strategy will be decided by us. Nothing in this world will influence that. So somebody and two countries will be fighting, and we are there being sandwiched between two countries fight because of lack of our foreign policy or something, and our nation, our people, our merchants will be killed in a very, I should say that, controversial zone, and the head of the sovereigns will be silent. That's not the constitutional sovereignty, at least. Got the point? So you can find out the similarity of the situation and try to solve the problem. Number 3, say socialist. And I am very happy that I am delivering the class, taking this lecture in Shubheshwar College. How many of you have heard about late Shubheshwar? He was one of the prominent socialist leader of our country. Because nowadays we do not hear about the socialist leaders' name. We have forgotten the names like Morarji Desai. There was a time, there was a constitutional turmoil in 1970s. You have seen emergency, post-emergency. Supreme Court, pre-emergency Supreme Court, post-emergency Supreme Court. That time, many socialist people, they started to develop the concept of socialism in India in the political mainstream, and late Shukeshwar was one of them. So let me take the opportunity to pay tribute to his memory. So now these socialists, secular, I will come. Before secular, let's deal with socialist. What do you mean by socialism? Any of you? What is socialism? Is a very bad word, dirty word, national, something.
Something which is for all. It's for everyone. It's for
It's a
everyone.
distribution, equal distribution of the resources. Equal distribution of the resources. But how? That was the debate. That was the debate when the constitution came in force. If you read the Constituent Assembly debate, you will find one debate by one person called Somnath Lai. He was one member from Bengal. He argued on this fundamental rights. He said there are two perspectives. When you launch a debate on the subject, there are two perspectives, right? So when you say something, when you say socialism is bad, that means you have a perspective. You believe that yes, this should be under the private ownership. Every land should be under the ownership of the private parties. That was the debate when India became independent and the constitution was enforced in 1950. What was the debate? In the initial debate, the entire debate was centered around the issue related to the land reforms. Throughout India, when the government of India decided to do the land reforms, that means there were the lands beyond the ceiling to the many people who were the earlier zamindars and others. The government decided to take away those lands by rule of acquisition, acquire it, distribute it to the landless. Then the entire nation, there were two perspectives created. Even in the Supreme Court, within the Supreme Court, two classes of judges started to fight with each other. Obviously, it's a philosophical fight. And you can read all the judgments. Till 60s, this debate went on in the Supreme Court. And ultimately, you have heard about those RC Cooper judgment and bank nationalization judgment, and where ultimately all this happens. I will be taking, I'm not going to take you to many of the Supreme Court judgments today. Let us be very specific on that. I would be saying that, I'll be quoting Justice Krishna here, once he said that to understand Indian socialism and the perspective under the constitutional perspective, let us, it's like, amalgam of Gandhism and Marxism. Justice Krishna was very lucidly used this term. It's an amalgam between Gandhism and Marxism, because that time these were the debate. Because one hand we had Soviet Russia, on other hand there was America and our system. If you look at the constitution making process, it was a bipolar. It was not done by looking at one constitution. Many things from many constitutions. And our constitution was developed with all the amalgam and the concepts of socialism in the constitution which was there. Though it was not reflected here. But if you look at the directive principles of the state policies, if you look at the other provisions, you will find out that the constitution framers, they had a vision to establish India into a social state. Then come to the word secular. What is the word secular means? Do you think that it has anything to do with religion? What do you think about secular country?
The state has no religion. The state cannot favor any particular religion.
Not only religion, even everything. The religion should not be the consideration of the foundation of the state.
Yes.
State should be based on the egalitarian principle. State should formulate its policy on the basis of justice, equity, good conscience.
Yes.
By giving the importance to the equality of opportunity, equality of opportunity, equality of status, and promote equality. So all this. The foundation of law should be based on this. Law of a secular state cannot make a law for particular class unless it is otherwise permitted to do. Exception is there. What is the exception to this? What is the exception to equality? Any constitutional exception? Can you give me any exception to equality? Very good.
Reasonable classification.
Article 15. That's the exception to equality. State can create an exception if it is permitted to do so by the constitution, not otherwise. Law would be otherwise secular. Law would be otherwise so-called, I would say that based on these principles, if not permitted to be made in different way. That means the Article 15(3). But you cannot say that I am going to make a law. This law is going to be applicable for this community and not this community based student. There may be some law you can find out. Nowadays from various controversy. I will reach to the controversy after I complete this. So you can find out the controversy from the contemporary Indian situation. The laws are made for a class of the people. Earlier we used to say the class legislation is bad. Nowadays the laws have been made excluding one class of people from our citizenship law. In 2019, you heard about Citizenship Amendment Act. There was a debate on this. Why the debate was generated? Because it had excluded a class. They said that those people coming from some countries will be permitted to apply for the citizenship, and some countries they are not. The only parameter was to be tested that whether they are sufferer of the atrocities of the majority religion in those countries. So those countries, in particular religion considered to be the majority, minority were allowed. Some countries they were not allowed. The law is still challenged. Supreme Court is still hearing the matter. It's going on 2019 to 2026. Anyway, that's another controversy, how the court should react in this. Then come to justice, liberty, equality, fraternity. Social, economic, political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, and to promote among all fraternity, assuring the dignity of the individual and unity and integrity of the nation. Kindly be very careful with this. Integrity of the nation 2, when it was substituted by section 2 of Unity of the Nations 1977. Rather, this was not there. 1977, this clause was inserted. Now can you say what is the called nation under the constitution? Is there anything? Whether nation is defined under the constitution? Whether nation is defined? Well, sometimes we are given an option to write what is the nationality. Is it defined under the constitution, nationality? Can anybody say that where the nationality is defined, where Indian word is used? We always, in a populist angle, we call it Indian constitution. There is nothing, no document called Indian constitution. There is no document called Indian Constitution in this world. This document is known as the Constitution of India. The Constitution of India means the Constitution of India. Nobody has a right to call it Indian Constitution. Whatever Indianness we are talking about, these are born out of the Constitution. First the Constitution, then Indianness, arising out of the Constitution. If you want to read this. Fine. So these are the things. In a popular parlance, we call it Indian Constitution, right? We also do the same mistake. Many persons. But you can't show me from the constitutional text that there is a document called Indian Constitution, the Constitution of India. There is a hell and heaven difference between Indian and the Constitution of India. When you talk about Indian, you talk about an Indianness. When you talk about Indianness, there is a debate. You may say this is Indianness, I may say that is Indianness. The constitution wanted to bring an equilibrium and resolve the problem by creating India. We the people of India having solemnly resolved to constitute India into what was intended to be resolved. A long-standing disputes which was going around in India for a long time. Disputes related to the settlement, disputes related to the rights of the people, disputes related to justice of the people, equality, right to vote, everything for which we had fought during the time of our freedom struggle. So every dispute was put an end by enacting this constitution. So we the people are having solemnly resolved to constitute India into this. So this is the character of the constitution. Then kindly come to this social, economic, political, liberty of thought, expression, belief and faith and worship, equality of status and opportunity, fraternity assuring the dignity of the individual and the unity and integrity of the nation. 1977, those words came with the amendment in 51A, that is the fundamental duties. That 1942 inserted fundamental duties, where you can find that feelings that of the nation and all. Because we must be driven by this. So, in this context, after reading the preamble, if I ask you that, how many of you think that right to vote is the first and foremost right of an ordinary resident of India? The ordinary resident of India, I am talking about ordinary resident. Why I am telling it, I will come later. I have not taken into any of the articles. Once I will come to the articles, I will tell you. I said ordinary resident of India. Anybody has a right to vote or not in India. Those who are ordinarily residing in India, do they have a right to cast their vote? How many of you think they have a right to cast their vote? You got my point? Do you think that the people who are residing in India, they have a right to cast their vote? Who has the right to cast their vote? Citizens. Who are the citizens? Who is a citizen of India? Who is a citizen of India? Let's read, find out from this book. Which article deals with citizenship? Can anybody tell which article deals with citizenship? Nearby. Achakachi. Go to open it. You'll find it. You have a constitution with you. Okay, open it. Take it. Chalo. Chalo. Article 5. Achakachi case. Now tell me who are the citizens. Can anybody say that who are the citizens after reading this? What is territory of India?
The boundary, the geographical limit of India.
Who says where the geographical limit is defined? Is it defined under the constitution?
Maybe it is defined in the part 1 of the constitution.
Yes,
After name, but how geographical territory is defined?
Article 1.
Read it. Take this. Is this interesting? I'm asking you because people say that constitution is a very boring subject. It's very interesting subject once you read it in an interesting way. Read.
Article 1. Name and territory of the Union. India, that is Bharat, shall be a union of the state. The states and the territory thereof shall be specified in the first schedule. The territory of...
Can you just find out that when you write the deeds of a house, when you go to purchase a building, you start in that way only. You define the schedule and how you get it. So it's also written in that form. First, it defines what is India. India, that is Bharat again.
India, that is Bharat. It's not Bharat, that is India. India, that is Bharat. That is another point of controversy. Go to the next thing.
The territory of India shall comprise the territories of the state, the union territories specified in the first schedule, and such other territories as may be acquired.
So, there is a possibility India can acquire a territory. That will be included. Can you give any example of any territory which was acquired by India later on, annexed later on with India after independence? Many places, Chandanagar, Goa, Kuchbihar, Pondicherry, I'm not sure about Pondicherry. Sikkim, later on annexed 1975. So territory can be included in India. But what is not permitted? The exclusion. Our constitution doesn't permit that exclusion from India, that the right to secede. It's not here. There are the constitutions in the world where right to secession is there. A particular area can go out of the country. But here we don't have that right. But no, citizenship. I will tell you. At the commencement of the constitution, this read it very carefully, because nowadays all of you probably after 1 or 2 months the law students will be required for the SIR process, because you have to go to the people and make them understand what is going on, because it's 27 lakh litigations that will be pending, already pending. At the commencement of the constitution, every person who has his domicile in territory of India, and so for the time being, find out the meaning of what domicile anyway. Anybody find out the meaning of domicile from Google? What do you understand by the word domicile? Domicile. Search it in Google. Permanent legal. So any person having domicile in the territory of India, who was born in territory of India, and either of whose parents was born in the territory of India, or that means the first condition, he must have a domicile. Who was born in territory of India, either of whose parents was born in territory of India. So these two criteria. Who has been ordinarily resident in territory of India for not less than 5 years, immediately preceding such commencement, shall be the citizen of India. 6. Notwithstanding anything in Article 5, a person who has migrated to the territory of India, read it very carefully, migrated to territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of the constitution if he or his either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935. In the case where such person has so migrated before the 19th day of July 1948, he has been ordinarily resident of India. I wanted to say, see, all these things you can read it from the constitution. But the first criteria which has to be satisfied to become the citizen of India is that whether you are a ordinary resident of India, whether you have a home in India, and if you are here and you were born in India, you don't have to satisfy any other criteria if you satisfy your birthplace and either of your parents is from India. This was the law. But this law was gradually tightened. 2003 there was that Illegal Migrant Act was passed. Illegal Migrant Act was passed with the view that
Yes, there are the illegal migrants. There are debate on this. When there is a border, there is a border security force. There is a border security force act too. Then you admit that there are illegal migrants. That means it is imperative that once there are illegal migrants, there must be the failure of the border security too. So you got my point. Why I am saying so? Why I am telling it? Because it is another controversy related to citizenship. Who is a citizen? The constitution. See, there are two kinds of citizenship law in the world. Some country they believe in the citizenship by birth, and some country they believe that citizenship, which is not only by birth, but it has to be also on the basis of other requirements. You must have the blood flow in that particular country. You have to find out. But we believe in that citizenship by birth or citizenship by acquisition. Means those who are staying here for 7 years as per the Citizenship Act and then apply for nationalization, they can. So these are the process. Now, this is another area of controversy nowadays. For what? You need to understand the constitution. In the Supreme Court in the SIR judgment has clearly stated that Election Commission has no power to deal with the citizenship, except they have a limited power to exercise to find out whether that citizenship is a genuine thing or not. In the name of this genuinity test, some people think that the question of citizenship has already been looked at. So therefore, many people say that this is like a citizenship foreigners tribunal thing which is going on. And many people say no, it's not foreigners tribunal. This tribunal will have no power to exclude any name from the citizenship rule, but they will. That is the SIR judgment, that is their SIR judgment. Now we talk about another, I say this, here you have found another word, that is the political. I will get into this next controversy and I will conclude by saying one example. What do you call as political justice? How many of you know what is political justice? Can you say? What do you understand by political justice? In your language, I don't expect any valid answer. I want a prudent answer. It may be very illogical also, but give me your answer. Political justice. What do you mean by political justice? Or anybody, you বসে যাও, অন্য কেউ বলুন। কেউ একজন পলিটিক্যাল জাস্টিস বলতে কি বোঝাচ্ছে?
So ensuring that every citizen of India gets equal political self-governance model while participating in the political framework of the country.
Right. That includes your right to participate in the political activities,
Yes.
right to cast a vote, right to contest in an election, right to form a political party, right to get it recognized, right to reserve the political party, right to retain the political party, but exclude some other people's right to take away the political party from someone who have promoted it. Why is this? Political parties are not like a formula. But the most important controversy today which has germinated in India from 2022-3 onwards to make the political party like the company, shareholding companies. When the electoral bond was passed, electoral bond related law that was ultimately struck down by the Supreme Court. And I had an opportunity to appear also in that matter too for one of the political parties. The first thing, why this electoral bond came, this money was infused. Earlier, corporate funding was limited to the political party. If you wanted the corporate funding, there are the rules of the Election Commission of India that you have to comply with the strict rules that if you accept more than 20,000, you have to give the details of the person from who are receiving that money. So if he is a corporate identity, so everybody will have an access to that. You will get that DIN number or something. You will put it, you will get everything related to that company. Whether the money is tainted, money is illegal, money is bad, money is black. So everything will come to know that who are funding the political party. But electoral bond created a cap for the identity of the companies who are giving the money. So their identity would not be revealed to the public. They were allowed to give the money. But virtually doing so, they have actually made few political parties, according to their choice, very rich one. And others were not getting any money. Some suspicious thing happened. Some political party which had no power at all, representation at all, got the highest amount of money compared to the most big political party of the country. A party who had no authority, who had no representation towards the country, got the second largest money in that electoral fund. Now what happened after that? Political parties became like the shareholding companies. In company share, you know that how these are being transferred. If company doesn't work well, all shares are sold out. But political party doesn't work in that fashion. But those who had the tendency to expose it to the market, they have suffered the debacle. Those who have accepted the money and given the money's test to the people who knew how to change it have suffered it. And the first incident happened in Maharashtra. And second incident happened in West Bengal. So these are another controversy which is coming up because this controversy is hitting একদম পিছনে চলে যাবে 10th schedule চলে যাবে পিছনে to one of the schedule of the constitution. I will conclude by referring to this 10th schedule because this is the third and most important debate in today's India related to the constitution. একদম পিছনে
Sir, can I interrupt?
yes.
Sir, what about the PM CARES fund? We have observed that RTIs have been rejected immensely. So, it is.
Okay, 10th schedule of the constitution. Schedule is at end. So once you complete the constitution, এদিক থেকে ওদিক চেঞ্জ করতে পলিটিক্যাল পার্টি চেঞ্জ করে I fought with the ticket of one political party I won. Later on I got an offer from other political party and shifted easily. So that was the starting point. The name was Iram Gairam, so this became a populist phrase that Iram Gairam case. So all these things are considered. Now, what is this statement? Now read the words very carefully and apply. I am not going to give you any direct instance. You yourself will find out the direct instance by reading it. House. House means either house of the parliament or the legislative assembly. Or as the case may be, either house of the legislature of the state. B. Legislature party. In relation to a member of a house belonging to any political party, in accordance with the provisions of paragraph number 2 of paragraph number 4, means a group consisting of all members of that house, not anybody who is non-member. It's only for the members of that house. Who is a non-member, who has not been permitted to come into the house, not for them. Paragraph number 2, paragraph means a group consisting members of the house for the time being belonging to the political party in accordance with the said provisions. Now come to the original political party. Original political party in relation to a member of the house means the political party to which he belongs to for the purpose of subparagraph 1 and paragraph number 2. Paragraph means Paragraph means paragraph of this. Legislative party means the party which is there comprising of its elected members in the house, assembly or parliament, parliamentary team or legislature team. Now they are consisting the group. Now this group can take a decision when an elected member of the house shall be deemed to be belong to a political party, if any, by which he was set up as a candidate for the election of such member. He is nominated with a symbol of a political party and then a nominated member of the house shall, I am skipping it, an elected member of the house who has been elected otherwise than a candidate set up by any political party shall be disqualified from being member of the house if he joins any political party after such election if he is individual. Somebody got elected from a political party as a candidate of a political party. Now changing his political affiliation after being elected, go to B political party. Individual capacity, in his individual capacity, then his membership becomes disqualified. But there is a saving too. You know, for the nomination member also he cannot join. Notwithstanding anything contained in the foregoing provisions paragraph, a person who on the commencement of the Constitution, 52nd Amendment Act 1985, is a member of the House shall, where he was a member of the political party, immediately before the commencement be deemed for the purposes of subparagraph 1 of this paragraph to have been elected as a member of such house, candidate set up by such political party. Now commonly come to the disqualification on the ground of defection not to apply in case of merger. Now, a member of house shall not be disqualified under subparagraph 1 where his original political party merges with another political party and he claims that he and any other members of the original party have become members of such other political party, as the case may be, of a new political party formed by such merger, have not accepted the merger and opted to the function as the separate group. So there can be three situations. Once there is a merger, the original party loses its identity, gets into another party. In a very recent case, which has happened with one political party, their parliamentary party is merged with another political party. There is no party. They have lost their identity in their lives. Here, they want to say it is not merger. We have to have not accepted the merger and opted to function as a separate group. There are two groups were operating. So this is the second case. This is in order to avoid the defection. Otherwise, if I change my political party in the individual capacity, it immediately draws the disqualification. So now, why I am referring to this, I am concluding here. The purpose of my class was not to teach you the constitutional problem as a whole, but to give you some impression of the problems and how to solve the problems. And I tell you, never compromise with this reading habit of the text. And never say anything. Being a lawyer, do not make any comment whenever it is not necessary. But when you make a comment, it should be backed by the text you are reading. Lawyers should be, it's not the orator. Some people believe that orators can be very good lawyers. Some people believe if you are a writer, you can be very good lawyer. Some people believe that if you can speak good English, you can become very good lawyer. None of these are the single criteria to become the lawyer. I call it that we are the master of none. We are actually jack of all trades. You need to become the jack of all trades. But you are master of one thing, that is how to do it. That's all. So you have to read it. So please read the Constitution. You will never get time. So I request you to read this document very carefully. and to give some sort of utilize your time to think about the constitutional issues. Whatever I have said, I think already 5 or 6 problems have come to your mind regarding the constitution. Though I have not used any direct instances, I have not given, and categorically I have not given, because so that it can instigate you to read it and read it more and more. So please read the constitution again and again. And I am really impressed by some of you who have participated, because class should be like two-way traffic. It should not be a lecture. Otherwise, the lecture at 4 p.m. is very bad. I understand the problems. Everybody thinks when to go. আন্দোলনের চাপ পেরিয়ে যেতে হবে, কিভাবে যাব, এটি বুঝলে না? তো এটা করতে হবে আপনাদেরকে, করবে। And I am thanking the faculty members and the principal of this college, as well as director, was my senior in the school also, and the director of this college, and to all of you, all the best. And I will be looking for my opportunity to come again. If you give me chance, I will come again to take some of the classes on this question. Thank you. If you have any question, you had a question regarding the RTI.
Yes.
Now RTI zone, now what is happened? The changes in the RTI zone. Earlier RTI was very clear. Like whatever application you could make, they were bound to give the answer. Now they brought an amendment to this. Some places they are requiring the reasons for your RTI application. Why have you made the RTI? So the scope of RTI has been attempted to be restricted by the parliament at the recent time. That is the problem. Any problem, any question anybody has? Anything. I won't mind to take any small questions to yes.
What is the root user trying to manage our privacy and the aiming of the techniques are trying to explain your role when they start the video or they jail.
Look, I think that you know about the contemporary issues. It is one of the most important issues, but I have consciously avoided this because these are often repeated offense by the police. I would be there. I mean, yesterday also, medium. It became medium like after pre-COVID and post-COVID period. YouTube channels and other things we started to do. So that was, I can say that the law is, as Justice Chandrachud's that favorite line was that, and I was so gentle to all, Arnab to Zubed. He said, A to Z, I have granted them well. So he forgot to mention the name of, what was the name? Sharjil Imam, Umar Khalid, and others. Let's not get into it. But the main thing is that if you read Arnab Goswami's judgment, Arnab Manoranjan Goswami. So some people call it Manoranjan Arnab Goswami. Meaning is said. Real meaning, Arnab Manoranjan Goswami. Then you go to there and you will find the yardstick. It said that if you have an FIR, doesn't disclose any cognizable offense. Suppose I say X is very bad person, it's a critic. X is dangerous person, it's a critic. X is a thief, critic. Perception. Go and kill him. Again, instigation, but not instigation because if he is not killing, you go there. It has to be the action. That was Rhea Singh. When 66A came, that was in 2013-14. Communication of in Bengal 2 or 3 in Bombay. Then Shreya Singhal challenged 66A, the constitutional validity of section 66A of the Information Technology Act. So it was struck down by the Supreme. Now the thing is that whether a mere utterance can be an offense. There are the cases where If people have been arrested because of using slang, can it be held to be an offense? I used a slang to another person, and that not at behest of that person too, he may have a right to be insulted. But the police doesn't have any right to initiate a proceeding against the person who has used slang. So modo he cannot. That's the instance of this. So this is the attack on the freedom of speech and expression. I think Madam will give me another opportunity to discuss on this one day. I will come and discuss on this. It will take one day. Today, I wanted to give an impression about the constitutional law. So, how many of you are interested in the constitutional law now? Sure. It was not boring. If it is not boring, if you have found it interesting, please keep yourself engaged in this activity. Because all these topics are the topics you discuss in the canteen, you discuss in the roadside, you discuss wherever you go. These are politics of these are the topics of real day-to-day politics. But that is there in the constitution. You just try to solve it by the constitution. Right? So it's a weapon. Use it as a weapon. Weapon for your study, weapon to build the proper citizen of India. That would be the constitutional nation. That is the nation which constitution framers, they have dreamt about. Nation under the constitution, not nation above the constitution. Thank you.